Okay, once again, we got police reports here. Just a quick rundown. Family court issues, manipulation involving the police, misleading the police with information that's not true, withholding information, and getting the police to make reports that are not true so that she can show them to the court. However, thanks to being very diligent and on top of things, I'm trying to put an end to that. So, July 21st, 2017, it was a Friday. I was driving a truck. I knew I wasn't going to make it back in time. Had serious concerns of that. I emailed my ex, and she did not tell the police that we had contact with each other. I was trying to reschedule till the next morning rather than have my 3-year-old waiting at a police station for her daddy to show up when I had no idea what time I was going to be there. It's a pretty reasonable request. So here's what she wrote, or at least got the police to document. So there's the date, July 21st. As you can see, it was at 5 to 7. Okay, and there's the police officers involved, and my ex, Caroline Thwaites. This is a non-reportable event. Comments. It said complainant reporting. And Wayne Stone is refusing to abide with family court order, saying that I was to meet up with Caroline Thwaites to pick up our daughter Jewel, who was 3 at the time, but did not show. This is a lie, okay? And I'll explain that to you. You see, hold on. Closing comments. Spoke to, and it's not my name, her name again, was spoken to regarding custody order and the fact that Wayne did not show up for pickup. She was satisfied with the advice given. Interesting. Well, the reason why she wanted it documented that I did not show up is because in our court order, it states that if I miss 2 blocks of time within a 6-week period, that she can withhold my child from me until we go back to court, or at least until I take her back to court. That's what she was trying to accomplish. However, when I brought it to the attention of the police, I brought in my emails. Oh yes, I brought my emails into the police along with the court order, and I said to them, I said, we've got a problem here. You are just documenting things that she's telling you. She's gave you incorrect information, deliberately misled the police in an effort to either have me charged for not following the court order and to have a police record documenting that I didn't show up in her effort to try to stop bringing my child to me. So this investigation in particular took place. Wait for it to zoom in here. Hello. There we go. 2019. Well, the reason why this report was done at this time, well, this date is the original date. This is the date of me actually getting this staff sergeant to finally comply with righting the wrong that they did. So he does his little, what is it here, advanced investigation. Wayne wasn't following the court order. Okay. Well, he says that I brought in a couple sheets of paper. He's just saying this to cover himself, you know. But really, they were the sheets of paper he's referring to are the emails that he's documented here. It's just ridiculous. Anyway, in any event, this is the clause in the, there is a paragraph in the order, paragraph 8, that converts off any unanticipated issues with access and believes contradicts the belief that he was failing to comply with the order. Well, it's not just my belief. Read it for yourself. If there is an unanticipated issue in connection with the access, the party wishing to give notice of the issue shall do so by email. And there it is. Unfortunately, I will be late picking up Jewel. I will be able to pick her up tomorrow morning around 9. And 13:04, so that was 4 minutes after 1 on the Friday, 5 hours before I was supposed to pick my daughter up. Okay. And she says, I can't accommodate this. So she's answered it a few times. I said, no, you need to be reasonable. I started back to work. I don't have a 9-to-5 career. I'm a trucker. Get used to it. Like, come on. She says, again, no, Jill will not be there Saturday at 9. She'll be there at 6 o'clock tonight. This is completely, not only unreasonable, she's out of her mind. So there's 2 clauses in this paragraph that state, one is for unanticipated issues. Okay. The other one is for if it is necessary to cancel or reschedule access for a legitimate reason, and I would think employment would be one of those, the party wishing to give advice to advise the problem shall try to give a minimum of 24 hours notice. Well, this is both. This is a legitimate reason. I'm at work, and it was unanticipated that I wouldn't make it back in time. So, further into this investigation, he then says, he has no evidence that I was working on that day. Well, I'll supply the logbooks or a letter from the employer, or stuck in traffic. Does acknowledge that there appears to be some communication between the 2 parties that what, if at all, facts are accurate, confirm compliance. So, given the fact that I have emails and I actually forward those emails to that staff sergeant, this proves that when she went in on July 21st, 2017, she deliberately misled the police by not telling them that there was communication between us and wanted them to document this, that he did not show up, that he was not following the court order. That's what she wanted them to document. She played them like a little puppet, and they danced any song, tapped their toe to whatever she wanted to sing to them. No charges laid for that once that was brought to light. Interesting, once again. That's the 3rd time since April 2016 that she's tried to have me incarcerated or take my child away from me. Interesting, isn't it?